cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
If it's lawyers at 20 paces, I know who I want. David Whiting is a Melbourne solicitor. Now that I've talked him up, say something terrific.
I'd rather be further away than 30 paces, Justin.
Is it a little too close for lawyers?
Absolutely.
Absolutely.
You can see the whites of their eyes. It's too close.
It's good to see you, mate.
Thank you very much.
Are you ready for some calls?
I am.
Mary's
before we do.
Yeah, please.
It wasn't homework. It was a
I'm
follow-up from last week. Harry from Moorabbin rang. He was in a fairly... I'm not going to say lackadaisical, but fairly informal subdivision where they get owners' corporations bills every 3 years, but they cover about 3 years of expenses. So his question was, can they do it? The answer is yes, they can, because otherwise you'd never be able to catch up, would you? So even if owners' corporation billed every year, every now and then you've got extraordinary expenses, you've got to be able to cover them. So yes. Sorry, Harry, they can bill you.
Mary's in Camberwell first up. Hello, Mary.
Oh, good morning. My question's about a will. I've made a will for myself using the form downloaded from the internet. I've had it signed and witnessed, etc. But a friend has said to me that it's easier for my will to be contested because it's not prepared by a solicitor. I'm just wondering if that's true.
I disagree with that entirely. The only reason, that you can contest wills on a couple of on a series of bases. The first is that you didn't execute it properly. Right. Now that one's very easily overcome because the Supreme Court rules now allow you to make application for probate for informal wills. So if you've botched the execution, it doesn't, there might be an extra step in the process, but that's not going to invalidate the will per se. Apart from that, if you've done it properly and you've dealt properly with your estate, your downloaded will or your will kit will work just fine.
Oh, right. Okay, that's great. Thank you.
It'd save you some money.
Mary, thanks for calling in. Yep. Frank is in Geelong. Hello, Frank.
Hi. My relative of mine is getting a divorce, and her partner is sort of saying because he put more effort into building the house, he deserves more than 50%. Is that correct? Can you do that?
Frank, we don't have... California, for example, has a process where everybody gets half, okay? We don't have that system here, and we ask the court to determine what allocation of the net asset pool is appropriate, having regard to initial contributions and need. So we assume that during the course of the relationship, what everybody put in is worth about the same, but we try and adjust for contributions made at the outset, windfall gains, somebody dies, leaves you $100,000 along the way, and what your needs are at the end. So the fact that during the course of the relationship somebody did more work on the property isn't of itself going to get you there. Does that help? So I think the problem I have with the question as you put it is you've got an assumption of equality.
Yes.
Right? So try and, the way I tell people to do it is to come along and, as far as possible, work out what you brought into the relationship when it started and whether there are any windfall gains along the way that change the balance. And then you've got to come along and say, well, is somebody in a position to, is someone looking after children? All of those issues are factors.
Yeah.
All right.
Okay.
Thank you.
Okay, thanks, Dave.
Thanks, Frank. If you don't mind me jumping in with a question, David, what do you ever see an easy divorce? And if you do, what's the ratio?
Well, the trick is you've got to take the passion out of the arrangement, and love to intense dislike. One might say they're pretty much the same emotion, just in a different direction. So if you look at the failed relationship as a business deal that's gone bad, but you both need to have lives going forward, and you can agree on what everybody contributed as we went along, they're the ones that are easy. 10% probably would be the guess.
10% are sort of amicable.
Well, they come along and, or I also suggest to people is that if they can agree on the asset pool, then what they could then do is go along and say, jointly engage a lawyer to provide written advice as to the likely outcome in a court hearing based on that given set of facts. And then use that as the basis for your negotiation, not what you learnt in a cocktail party.
Frank, thanks for the call. Simon's in Traralgon. Hi, Simon.
Yes, good morning, Justin and David. A client of mine, I cut her hedges, so I don't know her that well, but she recently lost her partner to MND the morning that they were due to go and get married and sign new wills. So she's now being left out of the process. The 2 kids that he had from a previous relationship are kind of ignoring her, so she's basically left with nothing. Now, does she have any claim?
Did they live together, Simon?
I believe they did. They'd only been together a few years, I think.
But if they were in a relationship for more than a period of every now and then you come across a will that's been prepared in anticipation of marriage, but it generally provides. Then you need to decide: does it deal with? But if it doesn't happen, then. So I'm assuming there is no such will. We're going back to the earlier will. If she was in a domestic relationship with this person for 2 years, or there were special circumstances, it would be possible for her to make a claim. So she's probably in a position where she could make a claim. It really gets interesting. If he had died immediately after the wedding rather than before the wedding, then what would happen would be is that she would get a statutory legacy of $500,000 or 540,000 or thereabouts, and half the residue, and the kids would have got what was left over. So if I was your friend or your customer, I'd be going off and getting some advice, and the advice she gets will depend upon the length of the relationship. Right.
And would she have to prove that they were living together with shared bills or shared bank accounts or that sort of thing? Well,
it's normally, they might be shared bills, but if when you move in with someone, you don't automatically go and change all the utility accounts. It might well be you just contribute to a joint bank account. There are lots of, I'll pay the electricity and you pay the gas type stuff. So there are lots of different ways. Also, you would get affidavits, if necessary, from other people to say, yes, they were a couple, they lived together, we socialised with them, we saw them in their home, those sorts of things.
Yep.
Simon?
Okay.
Thank
Cheers.
you. Thank you very much. It's 10:13. It's Justin Smith filling in for Raph Epstein, who's back on your radio tomorrow. And every Tuesday, David Whiting is here to answer your legal questions. Tuesdays at 10 o'clock on 774 ABC Melbourne. Robert's in Frankston. Hello, Robert.
Justin, David, g'day. David had the pleasure of meeting at the Tenants Forum last year.
Oh, wow, okay.
I haven't washed that hand since.
I'm going to ask, was it your left hand or your right hand, Robert? But let's not go there. Yep.
Come on, it's all right, Robert. It's already free. You don't need to do that.
What can I say?
Go ahead.
David, I happen to be a client, a tenant at a veterans housing organisation known to you.
Yes.
I have been seeking for over a year now to have my disgustingly contaminated, fouled toilet replaced.
So the note that I've got is that there's been a repair order made at VCAT, but the landlord is contesting it. How?
Correct.
How? How are they contesting? Are they applying for a rehearing?
They are.
Right. So what's wrong with the rehearing process other than VCAT delays?
I am unsure as to the basis on which they would contest it, and what might have happened, Robert, I can't put it any higher than that, is did they turn up to the VCAT hearing? No.
There you go. So it's VCAT made an order based on your say-so, and for whatever it is, the housing provider who is your landlord has said, oh, okay, I'm really sorry, tribunal, we missed it. We want to contest it. We'd like the opportunity of being heard. And in those circumstances, VCAT has allowed a rehearing. So it's not so much a contesting the facts that you presented, but they might like to add their own facts, which may end up with a different result.
They are contesting the facts which I have presented, and I've come to understand what actually occurred in the background. But I'm wondering, is there a way I can advance this? It is supposed to be an urgent repair, after all.
Then VCAT will treat it as an urgent repair. So do you want to make it an urgent repair?
I suppose I do, because they've already made an order saying, right, get this squared away by the 18th of April, which wasn't done. Yep. And the landlord has come back and said, we want a rehearing.
Yes. So what you might do, Robert, is you might write to VCAT and say, look, this process is not my fault, but I have this horrendous problem and I need it addressed. And it will be reviewed, and you will get an appropriate date from a VCAT perspective based on what you tell them.
Certainly. To whom would you direct this at VCAT? The president of the residential list, or what?
You would. I would normally address it to the registrar, who will refer it to a member for consideration. The registrar residential tenancies list at VCAT.
All right. David, thank you very much indeed. Hugely appreciate it.
Robert, thank you very much for the call. Lynn is in Ringwood East. Hello, Lynn.
Oh, hello. I missed your first call and most of the information. It might have answered some of my queries. My son has just instigated a separation after 14 years. There are no children involved. They bought a house together last year, sadly. My son inherited last year $110,000 from my mother, and he also is gifted $100,000 from myself and my brother.
Yes.
So he's brought 210, and then we gifted him another 20,000 because to make even anyway. So 230,000 he's got from us last year. It's been an amicable separation. There's no issues. They've just grown apart, so he's instigated the separation. He's paid all the bills for 15 years. She's worked part-time because he's supported her in various degrees, various uni things.
So
he's paid all
Lynn, it works this way. I would have thought that the fact she was working part-time and studying was a decision made or agreed to by both of them.
Yes,
So
definitely.
during the period of cohabitation, the 15 years, I think a court is likely to not distinguish between his contribution and her contribution, right? Because contribution is not simply measured by dollars alone.
Right.
Now, and we haven't discussed, and I don't need to, what they brought to the relationship 15 years ago, because you need to take that into account as well. But as a general proposition, the gift from the grandmother, I have no issue, that's easy. The gift from you and your brother, is there documentation that supports the gift, or might she argue that it was a gift to both of them?
No, there is documentation because they got a home. They've got the first home owner grant.
Yes. No, but
so we had, my brother and I said to my son, not to both of them, that we were gifting them.
Oh, you just put your foot in it. You just said we're gifting them. Now that means
we're gifting him.
Oh, okay. That was a slip, wasn't it, Lynn?
It was a slip.
Yes.
In writing, we are gifting him.
Then that's his argument that he gets that back before they divide. All right.
Right. Okay. And 100,000 inheritance
the two lots.
to him.
The gift in the will was clearly to him, not to her.
Yes.
But you need, if there was documentation in place that made it really clear that what came from you and your brother was a gift to him rather than to them, that strengthens the argument that should come out first. All right.
And then a split.
That's the starting point for the discussion, Lynn.
Right. Okay.
All right.
Lynn, thanks very much for calling in. We'll numbers 1300 222 774. Still got time for your calls. We'll come back with more of David Whiting in a moment. Denise is in Sandringham. Hi, Denise.
Oh, hi. I have an issue on Owners Corporation. I own an apartment that is 20 months old. There are 9 apartments, 5 of whom are owned owner-occupied, 4 of whom are owned still by the developer. Are you there?
Yep, we're listening.
Oh, sorry. Now, we want to have... we haven't had an annual general meeting, and yet the apartments are 20 months old. The owners, we have all owner-occupied...
when did they start selling them, Denise?
We bought off the plan in 2020.
Oh, I'm sorry. When did you settle?
Settle in late October 23.
Okay. You get 18 months for your first meeting, yes?
Right.
Yep.
Well, the actual problem is the 5 owner-occupiers have been contacting the owner of the strata management company by phone and by email asking for a budget and when are we having a meeting, and he will not respond to any of us. And naturally, we want to get someone else as our owner management company, but because he won't reply to any of us, we don't know what his contract is. We don't know where to go next because he won't reply and
Lynn,
won't answer phone.
Sorry, Denise, call a meeting.
Yep.
There's a process in the rules for the calling of a meeting. You will have sufficient people to force a meeting.
Okay, and we advise the developer who owns 4 apartments and the management company that this is what we're doing and this is an invitation to the meeting. Is that what we do?
But yeah, have a look and see what the rules say in terms of your owners corporation for process. Follow the process and call a meeting. And and at that stage, one of the things that you ask is for the manager to bring his contract.
Okay.
So the answer, sending emails and phone calls, have a face-to-face, but that's the way you force it. And if necessary, you might resolve, if 5 of you agree, you might resolve to terminate the manager.
Right.
All right. And then you might then hold another meeting to engage a new one.
Okay. Next question, though. The rights of owners, like there's 4 apartments that are the biggest apartments owned by the developer and 5 by owner-occupiers. So is the voting done according to how many units there are or how many square meterage that people own?
There's a statement of unit liability and entitlement contained in the plan of subdivision. And normally at an owners corporation meeting, or it's on a show of hands. In the event, though, that someone asks for a poll, it's based on unit entitlement.
Denise, thank you very much for calling in. Still got time for a couple more. 1300 222 774. Lynette is in Montrose. Oh, hi, Lynette.
Hello, how are you?
Yeah, well, wonderful. Go right ahead.
I live in a retirement village and I have a broken window. Now, I have a lifetime lease in this village. I bought in as a lease. I don't own the build. I don't own it. I have a lease, and I pay maintenance every month. Now, when I came in, I thought that maintenance was for my unit, but it's for the whole village.
Well, and what you're actually doing is, what you're doing, Lynette, is you're paying a contribution to a maintenance pool that covers the whole of the village, yeah?
Yes. And I have a broken window, and I did not break it. Now, they're saying I did break it, and I have to pay for it. But in my lease, it says that they're responsible for all windows and glass. And I went to a mediation place and the manager refuses to talk to the mediator anymore. So I don't know what to do.
I'm going to ask you, I understand, but you've got a lease, right?
Yes.
So it's a retirement village issue. Can you wait till next week for the answer, Lynn? Lynette, I'd rather get the answer right, given that you've gone presumably to Dispute Resolution Victoria and to Dispute Settlement Victoria and not got the answer you were looking for, because it's an entirely voluntary process and you can't make them come. And I'll try and give you a better answer next week, Lynette.
Lynette, just hold on the line there for us if you don't mind. Gary is in Bundoora. Hi, Gary.
I've got a type of a gum tree growing on the nature strip, and there's power lines going over that. Now, the council have prune the tree so the tree grows out instead of up. Now, the tree that's going out is going all over my front yard. Can I cut that in line with the fence so it doesn't hang all over my house?
Well, there's been some reports in the paper of the last couple of weeks in circumstances where the cutting is said to make the tree unstable and more likely to fall. So you don't have a problem on one level. You have no difficulty in, yes, you could cut the tree at the fence line. Not a little over the fence line unless it's on your side, but certainly not just over the footpath. So yes, you can trim the tree, but you just need to make sure that whatever you do isn't going to be so drastic as to destabilise it.
Okay, great, because it's just the amount of mess that it comes over, and they grow that far out, and they've just let it go before you know it's been pretty much over my house.
Yeah, you can cut it. But you might have a discussion with the council about what you're proposing to do, and you might also leave the surplus branches on the nature strip because they're theirs. All right?
Gary, thanks for the call. Jack's in Northcote. Hello, Jack.
Oh, good morning, Justin and David. David, it's just a quick one. I was wondering if you had heard of the Victorian Will Bank and if there are any disadvantages in submitting your original copy of your will to the Will Bank.
No, I certainly know of them. I've not had dealings with them. It's an organisation which offers to store your will. Now, the difficulty that sometimes arises is that you'll make a will with someone and you will leave it somewhere, but who knows where you've left it. There's also a process where you can leave your will with the Supreme Court. You can store it in the probate office at the Supreme Court if you want to. You pay a fee for it, and you can take it out if you no longer want to have them. Most lawyers hold wills without a fee. So if
my lawyers actually they didn't go broke; they struck off.
But if you contact the Legal Services Board, send them an email to records at Legal Services Board, they will tell you who is the holder of that firm's records. And
I know who they are. I'm just this is mitigating in the future. That's all. I've done another will,
yes,
and I would prefer to submit it to the Will Bank. That information came with the kit that I originally got a couple of decades ago from the state trustee who made me aware of this Will Bank. But I thought it was a government thing. I didn't realise it was a private thing.
Private.
Okay.
Yep.
All right.
Jack, thank you. Sorry, Jack.
Do you have any recommendations?
I would do a couple of things. I would probably leave it with the lawyer who made it for you, and I would.
Yeah, but I can't contact her. She was working for the firm that got struck off.
Well, again, the Legal Services Board will tell you where that lawyer now works if that suits you. The other thing you could do is give a copy to your executors, because it is possible to prove a copy will if the original can't be found.
Jack, thank you very much. And David Whiting, Melbourne solicitor, good to see you again, mate.
Thank you, Justin.
Very much.